Welcome to the EPG Pathshala. This paper is the philosophy of law. The current module is the philosophy of law, review and conclusion. The objectives of this module are to review all of the modules in this paper and to summarize the orientation of the paper as a whole. This module was written by Akash Singh Rathore, that's myself, from the Lewis University of Rome. In this paper, we have been discussing the philosophy of law, which asks fundamental questions about the nature of law. These are questions like, what is the meaning and significance of law? What is a law, and how do you determine the distinction between law and other forms of organization or other norms and rules? For that matter, what's the difference between law and morality? What is the nature of legal obligation? What is obligation? And what's the difference between legal obligation and moral obligation? These are the kinds of foundational questions that several of the modules have asked in various ways throughout the entire paper. Now, in attempting to understand the nature of law in this paper on the philosophy of law, we haven't been exclusively concerned with the theoretical aspect or the fundamental questions isolated from any particular context. Indeed, all along, we have also been oriented toward the philosophy of law in India specifically. So the specific context, geographical, cultural, religious, and so on, contextualization for what constitutes law, not just as such, but also within the Indian context. Several legal theorists and prominent judges, you can think of Professor Dhyani or the Supreme Court Justice Krishna Iyer, have argued that there's a serious problem in jurisprudence or the philosophy of law because the primary theoretical contributions that we find in the philosophy of law derive from elsewhere, specifically from Anglo-American jurisprudence, while the context that we have here in India demands or would often seem to demand its own more authentic theorization. So the problem that both legal theorists or philosophers of law and judges have faced in their practice is that there seems to be a mismatch between the theoretical aspects of the philosophy of law in India, which are by and large imports and implantations, with the actual ground workings of law in the country. To try to deal with this paper has been divided up into three separate kinds of modules or rough divisions. These divisions correspond in some respects to these two sorts of issues that I have just mentioned: questions of the philosophy of law as such, and questions related to the philosophy of law specifically in the Indian context. In this respect, the first roughly 1/3 of the modules of this paper have been preoccupied with the philosophy of law as such. Now, what that means is the way that jurisprudence is basically taught at law schools and in philosophy of law classes all around the world, especially the Anglophone world. And that suggests that we're talking primarily about Anglo-American jurisprudence, since it sets universal standards for common law and Anglophone jurisprudence. In this exercise, we've looked primarily at the history of the philosophy of law from John Austin all the way up to Joseph Ratz, and we've discussed legal theories that are dominant and taught in Indian law schools as well as law schools all around the world. The second set of modules then moved on to the contextualization of the philosophy of law in India, and this dealt with a number of context-specific approaches to the philosophy of law. So, for example, modules on Ambedkar and law, Gandhi and law, and so on. And then finally, in the third rough division of the paper, the last third of the paper, these modules were focused on case studies, specific cases which exemplified in some way or another both the universal aspects of the philosophy of law or the particular aspects of the philosophy of law. These 3/3, or this division into three of the paper on the philosophy of law, has served to inform us about the nature of philosophy of law as such, the nature of philosophy of law in India, and certain problems and conundrums related to both the theory and practice of law through specific cases that we studied in the last third of the paper. So after discussing the overall structure of the paper, we're now going to review these modules in more specificity, going one by one through the three parts, and then we'll summarize what we've discovered about the philosophy of law in India as we conclude this presentation of the final module. We're not going to discuss each module. Instead, we're going to present the key ideas that represent the thrust of this entire group of modules, numbered 2 through 16. So in Module 2, remember that we learned that legal philosophy is a distinctive field of knowledge at the crossroads between law and philosophy. So it's neither philosophy pure and simple, nor law pure and simple. It's an interdisciplinary field that stands at that crossroad between the two. Its main purpose is to explore the nature and function of the law in its most general sense. So in the second module, we identified two main traditions that have held the field in contemporary debate. Those are natural law theories on the one side and legal positivism on the other side. The module focused on the main philosophical conundrum of legal philosophy, that is, the distinction between law and morality. This has been a problem for many, many centuries. And in Module 2, we outlined some of the most important contributions to this debate from a historical perspective. Speaking of the historical perspective, then, we moved on in the third module to discuss canon law. Now, canon law was meant primarily for theological purposes or for the control of the church over its jurisdiction. Nevertheless, canon law has exercised a very significant influence over the history of Western legal and political developments. This was not only from a merely historical point of view, but as the German jurist Carl Schmitt argued, canon law shaped in some decisive ways the legal structure of modern nation states. So even though the discussion of canon law seemed like a historical exercise, what we found through certain jurisprudential theories, specifically Carl Schmitt's and many other contemporary ones that tend to agree with him, what we found was that the nature of theological law or canon law has been in some way secularized and transformed into the modern legal systems that we have. Now, Module 4 introduced students to very diverse legal theories using the fictitious case of the Speluncean explorers. What students learned is that different decisions, so the judges made decisions about the Speluncean explorers, and all of these different decisions are not just the result of different facts. The facts were always the same, but the judgments came out differently. So what made the judgments come out differently from the same facts? That is an illustration of the central importance of the philosophy of law, because the different legal theoretical approach that the judges took gave us different outcomes, different judgments based on the same set of facts. Now, seeing that identical facts can produce completely divergent judgments, in some cases guilty, in some cases not guilty, tells us how important it is to understand the nature of legal reasoning and philosophical thinking about the law. Module 7 tackled the subject of natural justice. The principles of natural justice guide procedural norms, which aim to prevent the miscarriage of justice by providing an independent, impartial, and unbiased adjudicatory body, guided by fair procedure and accompanied by justifiable reasons. So the role of natural justice in law can't be overestimated. If we have on the philosophical side a set of theories that serve to explain how the same facts lead to different judgments, from natural justice we learn from the procedural side how each of these must always come about through fair and impartial processes. In Module 8, we turned to another sort of theoretical aspect, a theory of human rights. In other words, the discussion was on the long tradition of the critiques of human rights, which is not something that we normally hear about in the philosophy of law. Contemporary critiques of human rights like those informed by Hannah Arendt or later Giorgio Agamben, have focused on the paradoxical tension between man and the citizen as the bearers of rights. Now, this original tension had the effect that precisely those most in need of protection, of course, stateless people, refugees, men as such, were denied these rights, denied their human rights that apparently applied only to citizens. Postcolonial theory also accuses human rights of a false universalism that is an expression of its Western bias and that obscures the suffering of the non-Western other. Finally, in this long history of the critiques of human rights, the module showed that Slavoj Žižek and Jacques Rancière also emphasized the tension between the abstract universalism of the Declaration on Human Rights and its particular application. But these, as we call them, post-Althusserians, see in this tension the very source of the political efficiency of human rights. The ninth module attempted to piece together a Marxist theory of law. Marx didn't write one systematic work on the topic, but his writings contain numerous critical insights on the workings of the bourgeois system of law. What that is was, of course, explained in some detail. These insights together form a constellation of ideas that were presented in the modules as a Marxist theory of law, which is a very important conception, especially in India, with a lot of social-based legislation. The 10th module aimed at showing the inextricable connection between knowledge and experience and how the learning of excluded, in this case specifically disabled, populations is not used due to their excluded status. So the induction of such excluded knowledge into dominant understanding doesn't just benefit the people who are excluded, but it actually benefits all of those under the law. This conclusion was demonstrated by recounting the manner in which the disability perspective on law has enhanced the robustness of major legal concepts. In Module 11, we moved on to a very specific work, that is Jürgen Habermas's book, Between Facts and Norms, Contributions to a Discourse Theory in Law and Democracy. This is a major international work in legal and political philosophy. Rich in ideas, the book has been systematically developed across a broad range of disciplines as different as sociology of law, constitutional and democratic theory, legal studies, and so on. The book examines a multitude of intellectual traditions. An important aspect of this work is that it bridges continental and Anglo-American outlooks, absorbing Anglo-American legal and constitutional theory, which has been so important in India, into a primarily European theoretical framework of law. Now let's move on to the second domain. If you remember from the introduction, we mentioned that these modules, specifically modules 17 to 26, are devoted to the particularities that contextualize the philosophy of law in India. These allow us to theorize and comprehend the distinctiveness of Indian philosophy of law. In this section, in other words, in these modules 17 to 26, now we move on to a review of the modules from the second domain. If you remember from the introduction, modules 17 to 26 fall into this specific domain devoted to the particularities that contextualize the philosophy of law in India. These allow us to theorize and comprehend the distinctiveness of Indian philosophy of law. So now in this review, we're just going to discuss some of the important points from these modules in this domain. Module 17 was quite crucial in this respect. It addressed the meaning and scope of the term Indian within the title Indian Philosophy of Law. In that module, we looked at the nature and status of the philosophy of law in India today, that is the 21st century, and that puts a focus on the idea of how we need to re-understand law in a post-independence context. But as we saw, what law in India is today owes an immeasurable debt to the era of colonization and above all British rule. After all, the very idea of law as we presently conceive of it in India is largely a transplant of 17th to 20th century British developments. Thus, when we consider jurisprudence in India, whether we're talking about constitutional law and its philosophical interpretations, to criminal law, the law of contracts, and so on, we generally envision this wide historical epoch and circulate our attention back and forth from 21st century developments to their 19th or 18th century British origins. Then we return again to contemporary developments. So Module 17 put all of this into some perspective, the nature of the philosophy of law in India in relation to its historical context, in relation to the nature of philosophy of law as such. In Module 18, which was on Hindu law, we saw how Hindu law has its own history of transformation. from what was known as classical Hindu law, where its rules were applicable in all civil and criminal matters, to modern Hindu law, where Hindu law became limited to the sphere of personal law or family law. And that's where it stands today. Analogously, Module 19 treated of Sharia. This module focused on the place of Shariat in post-colonial Muslim political discourses, exploring the ways in which constitutionally granted minority rights are identified as potential sources for articulating political arguments and position. The module raised two conceptual questions. What are the forms in which Shariat is represented as a political issue? And how do these varied political forms draw legal constitutional legitimacy? The 21st module was devoted to Gandhi. It discussed and analyzed Gandhi's engagement with law over the course of his life. The law undoubtedly played a major role in Gandhi's life, and arguably his training as a lawyer contributed to his larger persona as the father of the nation. In the next module, Module 22, we turned to another giant of Indian history, B.R. Ambedkar. The question the lesson explored was whether there is something which could be called an Ambedkarite vision of the law, which is not limited just to that saying that we have that he's the father of the Constitution. The module pointed out three specific ideas. First, that the idea of law in Dr. Ambedkar's body of work extends beyond state law. Then, that the key Ambedkarite conceptualization of law is as a counter-majoritarian force to be mobilized on the side of the Dalits against the law of Hindu society. And finally, legal concepts Dr. Ambedkar espoused, such as constitutional morality, have been rediscovered today as tools to combat new forms of oppression as the history of the nation unfolds. The last module we're going to discuss in this second domain is Module 26, which turned to the Adivasis. Positioned at the bottom of India's socio-cultural, economic, and political pyramid, the Adivasis in India continue to live on the margin after almost 7 decades of independent governance with a modern constitution. With the stigmatized identity coupled with isolation that has been their fate for a long time in history, the Adivasis remain part of society, but as this module attempted to show, they nevertheless are far removed from the mainstream. Finally, we're going to move on to a review of that third domain of the paper, that is modules 27 to 40, those which treat of legal concepts and thematic studies that function as case studies illustrating the diversity and wide-ranging scope of the philosophy of law at the Indian and the trans-regional and the international levels. Again, in this review, we're not going to discuss every module, but instead present a few key ideas that represent the thrust of this third domain. Module 29 covered the legal political problem of secrecy, which is required for reasons of security in a democracy and often also for enhanced forms of deliberation. The same requirement of secrecy creates limitations on the democratic process itself. Secrecy, by its obfuscation, poses challenges for democratic structures of accountability. No form of oversight works, be it from the legislative, the judiciary, or the media, because of the atypical nature of the secret that allows for extraordinary controls over the dissemination of information by the executive. So this module argued that periods of emergency or security threats lead the other branches of the state into deferring to the judgment of the executive in matters of national security. This threatens acts of dissent. In cases where there are no possibilities of democratic checks over abuses due to secrecy, democracies would have to rely more on whistleblowers who come out in the open and reveal instances of injustice or democratic deficits. So this module also discussed certain cases of whistleblowers and how to think about them in relation to the philosophy of law. Module 31 tackled the problem of Dalit human rights. The problems of untouchability, discrimination, and human rights violations against Dalits have a long history. Attempts have been made in the past and in recent times to establish an egalitarian society, but after 68 years of independent governance and 67 years after passing the Universal Declaration of Human Rights, Dalits are still struggling for freedom, for dignity, and justice. Dalits are humiliated, killed, raped, discriminated against, and suffer various other human rights violations on a regular, indeed on a daily basis. Despite Article 17 of the Indian Constitution abolishing untouchability, and stringent laws being passed, the law has at times proved ineffective in dealing with the monstrous attacks on the dignity and human rights of Dalits. Jumping to Module 39, this one covered the very controversial case of enforced medical treatment of death row inmates. The module showed that within the current Anglo-American legal system, the justification for forcible medical treatments of death row inmates is very difficult to defend on either moral or on legal grounds. On the one hand, the impossibility of changing the prisoner's sentence makes it problematic to claim that involuntary drugging would represent a better option for him. On the other hand, the will to reestablish competence in the patient in order to ensure that his suffering is fully proportionate to the crime that he committed is also a very difficult concept to accept. So the third domain of the modules have shown these cases, both local and international, and cases that relate back to the philosophy of law as such, the first domain of the paper, and the philosophy of law in India specifically, the second domain of the paper. What these cases and problems have illustrated is the way in which our treatment or dealing with specific cases of either local, national, or international significance nevertheless remain vectored largely by the jurisprudence that's found in the first domain of the paper. So, as we discussed in the introduction, a crucial aspect is to allow for the third domain, what we presented in the third domain, the kind of cases that are relevant within the philosophy of law in India. So what we had said that the task of the philosophy of law in India is to represent that the kinds of issues we discuss in the third domain, these cases and these issues that arise specifically within the Indian context, should be able to be dealt with from the vantage point of the second domain, that is, the philosophy of law as presented or developed or evolved within India itself, rather than those imports from Austin to Rats. Now this brings us to the conclusion, the way of summarizing how we understand what we've done in this paper and the orientation that we've been leading towards. As we've mentioned, the first domain gave us the philosophy of law from an Anglo-American point of view. As we have discussed in other papers within the philosophy program, for example in political philosophy, what students of philosophy in general would be familiar with is that there is a newly emerging notion within social and political philosophy that the social and political ideas that are transacted within post-colonial nations or environments like India should be authentic. That is, they should arise from the soil rather than being imports or transplants. If we are dealing with political or social problems within the peculiarity and distinctiveness of the Indian context, the use of concepts that have arisen in other social and political circumstances may not necessarily be apt to the problems that we face. So the current generation of thinking in social and political philosophy in much of the post-colonial or decolonial world argues that the concepts that we use in social and political theory need to be cleansed or we need to slough off the importation paradigm of using concepts that have evolved in other social and political circumstances. Well, the current trend in philosophizing about law is just the same. Why is it that the terms that we use in law, that the theories that we depend upon, rely upon for different kinds of thinking about cases and judgments, why is it that these theories have derived on foreign soils, in foreign contexts, in foreign judiciaries, and in different kinds of jurisdictions? So the task of the most current pioneering generation of philosophers of law is very similar to those of social and political philosophers. So the task of the current generation of legal philosophy is analogous to that of social and political philosophy, to slough off the concepts of foreign origin and come up with concepts that refer to the best practices of the indigenous tradition, what the anthropologist Clifford Geertz refers to as near experience concepts. Well, this is what this paper has attempted to point toward. It hasn't executed it by any means, but it's pointing towards this way of conducting jurisprudence, which is crucial to introduce in law schools in India. As we discussed at length in the introductory module, there is a standard model of jurisprudence, and you can go back to the first module to see what that standard module is. The standard model is one where jurisprudence is represented as almost an entirely Anglo-American theoretical experience with Indian cases tacked on as illustrations. Now, obviously, this needs to change, and we've made a lot of steps toward changing that in this paper. In this paper, instead, we've presented the insights from the standard model, but we've supplemented it also with a great deal of attempts to theorize the philosophy of law from the Indian context, with these modules on Gandhi, on Ambedkar, on ways of querying law, on the disability perspective that correlate to actual events unfolding in India today. Now, the attempt to create an authentic Indian philosophy of law raises the issue about the nature or meaning of that authenticity. The greatest risk in this orientation toward authenticity in social, political, and legal philosophy in India is the equation of authentic with ancient or former or previous or prior or traditional. Now, a great deal of tradition is inegalitarian, is overly conservative, and not in harmony with the movement of society, Indian society today, contemporary Indian cultural values, which are even widely accepted, though they differ from the previous centuries' norms. So how is it that we can equate the authentic with the ancient if the ancient is not in corroboration with the lived experiences of the Indian people? So this is a red herring. This is a misplaced conceptual arrangement where we think that the authenticity of Indian concepts correlates to the ancientness of Indian concepts. Rather than, this paper has tried to focus on developing authenticity in a downward movement to the people, so the lived experiences of the majority of people in the country. This is the place where concepts, social concepts, political concepts, and of course legal concepts need to find their origin. What are the ways through which the majority of people actually live and experience law, legislation, justice, and similarly basic questions about the nature of the law? It's the task of the future generation of legal, political, and social philosophers to conduct these kinds of studies where they understand what are the lived experiences and best practices of legal concepts within the actual contemporary history of India. That's where we're going to find the concepts for theorization, so that ultimately, as we have argued throughout this paper, all of the cases and conundrums that we presented in the third domain of this paper can be answered not by looking back at John Austin and the long tradition of Anglo-American legal philosophy from Austin to Joseph Ratz, but by looking back at the theoretical writings of India written within India with an Indian context and conceptual sensitivity in mind. So in conclusion, this has been the main aim of this paper and its 40 modules, the philosophy of law in India, not just the philosophy of law as such, and hopefully this paper has presented a new model for use in teaching jurisprudence in Indian law schools and other departments of the social sciences, show that when we understand the philosophy of law in India, we don't just mean putting together the Anglo-American philosophy with the Indian practices. Thank you.